It's great to have Andrew Parascandolo from Powell, Eddison, Solicitors in Harrogate in the studio with me. Andrew, thanks so much for coming in. Today we're just sort of talking through wills, trusts and probate, and it's, I think, an often misunderstood area of the law, and again, just to guide people through. The big hot topic at the moment, I see it, is why should sort of people make a will? It's sort of very much out there, it's being talked about, but I don't think really people have got a grasp as to why and what it entails.
Well, first of all, thank you, Alex, for inviting me to your show. Very kind of you. Yes, I think it is a very hot topic. The statistics say that around 50% of the population don't have a will. There still is almost like a myth that people think that only wills are supposed to be dealt with by the rich. Yeah. Certainly not. We do regularly advise clients to make a will. They don't have to cost lots of money. They can cost a few £100s, obviously depending on the type of will. But essentially, a will, what it does is it details what happens with your estate after you die. So things like your money, your personal possessions, properties, what happens to them after you die. And essentially, if you don't leave a will, it's the law and the laws of intestacy that decide how an estate is dealt with, who deals with it, and how it's distributed.
So effectively, your estate could effectively just gets passed to the government, or how does it work if you don't have a will in place?
Yeah, I mean, essentially it's not as drastic as that. A lot of people think it is, but under the rules of intestacy, it goes down the bloodline. So it would be things like people like siblings, sons, daughters, partners, etc. Mainly wives, not partners. But the will allows you to decide how your estate is distributed. It's not the laws of intestacy. So, as I say, because they are literally a few £100s to put together, it's really, really important for people to make wills and have them regularly updated. We generally say around 5 to 6 years to review your wills.
No, I agree. And the other sort of, I suppose, major buzzword out there is an LPA, or a lasting power of attorney. And again, it's a phrase commonly sort of thrown around, very much involved in the will sector. Just sort of talk everyone through that, what it means, what it actually entails, and why you should actually look at it fairly strongly nowadays. Yeah,
I mean, in my view, I always look at it like this. A will is how to deal with your estate after you die, and that deals with things like incorporating stepchildren. You may want to exclude family members, you may want to appoint guardians for young children, etc. Deal with remarriage, divorce, as well as estate planning. But lasting powers of attorney are essentially the way of administering your estate whilst you are alive, so that if you are unable to make decisions about your property, your finances, your bills, etc., not just because you've lost capacity, it may be that you've lost mobility, then a lasting power of attorney is a really good way of doing that. A lot of carers essentially have the buzzword of lasting powers of attorney. Go make one, it's really, really important. Now, the first thing that I say to a client is, you want a lasting power of attorney, why do you need it? So that's really why people come and get advice about lasting powers of attorney.
So if, for example, I sadly get knocked on the head and, God forbid, I'm in a coma or something like that, if I didn't have an LPA sort of paragraph or something set up in my will, how would it then work? How could someone then take charge of my financial affairs? Is there a process that one needs to go through, or how does it then work?
Let's look at it slightly differently. A will deals with your estate after death.
Yeah.
And that only becomes valid when you die. In terms of the lasting power of attorney, that is whilst you're alive. That comes to an end upon your death, and that's where the will takes over.
Got you.
So if, for example, you were, God forbid, taken ill or run over by a car and had mobility problems and maybe capacity problems, if your spouse or a family member didn't have a lasting power of attorney and they needed access to your funds, they would have problems doing that.
Yeah.
It just depends. People have different estates. They have different combinations of how they hold their money. There may be joint accounts. There may be single accounts. And it's just really talking to the client. And not everybody will need a lasting power of attorney.
Yeah, I think this is a fantastic point, Andrew. Although whilst the phrase LPA, lasting power of attorney, gets thrown around sort of fairly freely, actually, it's not necessarily right for all and sundry, and you need to speak and talk it through in detail because it may not be the right option. And how does it work? I mean, you hear again quite a lot in the news about wills being contested and other family members. I know you sort of slightly joked and saying, well, the one member of the family is sort of left out the will and then it all gets into the news. And these tend to be the obviously very high-profile cases. With your experience and your knowledge of the sector, do you find that this is a growing area, and what's the reason for it? Has there been a change in the law, or why is that? Or is it just the media?
Contested probate has increased in the last 24 months by 2,000%.
Gosh.
And I do think that a lot of it is to do with there is a case that's just been in the media, which is Ilott and Mitts, and essentially that was a case whereby a lady was estranged from her daughter for a period of around 20 odd years. She then made a conscious decision to distribute her estate to charities. The daughter contested that and was awarded an amount of money by the judge. She then was not happy with that, so appealed it. The appeal judge effectively increased the amount of money that she got, and then the charities then appealed to the Supreme Court, and now the Supreme Court has now ruled that the appeal judge wasn't correct and has reduced the amount back to the original amount. So in my view, that case really is a case that sits on its own facts. It did attract a lot of attention. It did attract a lot of emphasis for contested probates and contested wills. However, that, in my view, is a victory for testamentary freedom. At the end of the day, people should be allowed to leave their estate how they feel fit, as long as they've been properly advised.
But quite,
and that is the problem. We need to make sure that your listeners are properly informed, that they need to just sit down with someone. It needn't cost lots of money to sit down, find out what their objectives are, and then someone will weigh up the pros and cons.
I mean, great insight there, Andrew. And obviously bolted on the back of this is probate, again, term widely thrown around. Just Lucy, just sort of talk everyone through what it is, why it exists, and how to actually navigate through it all. I
mean, essentially, probate is the administration of an estate after someone passes away. It is the formal application of the grant of probate if you leave a will. If you don't leave a will, then it's something that's called letters of administration. And essentially, it is a series of documents that allows you to proceed with the estate. So the grant of probate, once obtained, allows bank accounts to be closed and the money to be collected, properties to be sold. And the one thing that I do want the listeners to be aware of is that which has not been publicised very much, is that the probate fees are just about to increase. And I think that it will have an impact on how people deal with their estate. There will be estates whereby people try to reduce the risk of this increased tariff by making decisions such as trusts. They may decide to reduce their estate by the use of trusts. It will also put executors in difficult position simply because they will need to fund this new tariff, which in some cases will be really difficult.
Andrew, I've got to say, some amazing insight and some great sort of tips for everyone. If anyone wanted to get in touch with yourself and your team at Powell Eddison just to talk through sort of the wills, the probate, the trust aspect, just to talk through their personal circumstances, what's the best way to get in touch?
Well, thank you for that. I mean, it's my pleasure. If people want to sit down and speak with us, we offer a free consultation period. Doesn't cost any money. It's free of charge, where people sit down with us. We then talk through their objectives. One thing I would say is we're no longer on at 14 Albert Street.
Yeah,
we've moved. We're now at Raglan House.
Yes,
thank you. We're now at Raglan House on Raglan Street, and we are having our official office opening on the 29th of March at 5 o'clock. So we invite all our clients to come and see us. Those that can, to maybe sit with us and have a drink of a glass of wine or maybe some champagne or some orange juice, and to meet the team and the rest of the new team that's come on board. The telephone number is as it always was, so it's Harrogate's 01423 564 551. And the website address or the email address is info@powell-edison.co.uk, and you can visit our website at www.powell-edison.co.uk.
Andrew, can't thank you enough. Fantastic information there, and thanks for coming on.
Thank you for inviting me.